So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
A courtroom can turn out to be the worst place for a corrupt cop, as their corruption gets exposed and they are sentenced to life. Here are some unforgettable moments when these tyrants were tried in court. This Border Patrol agent believed he was untouchable, abusing his authority while on duty. However, things took a turn when a man became furious with his behavior and chose to file a case against him.
When you're at the Border Patrol checkpoint, your duties are to enforce immigration laws and look for terrorists and look for weapons of mass destruction and assist in detecting narcotics. Is that correct?
Yes, sir.
And when you do this, of course, you're following a procedure manual that tells you what to do?
Following policy, sir.
Written policy?
Yes, sir.
You have a copy of that written policy?
No, I do not, sir.
Have you ever seen a copy of that written policy?
That states our authority to conduct immigration checks or for the checkpoint itself, sir?
For that checkpoint.
No, I have not, sir.
Are you aware of any written guidelines or policies or procedures on how to run that checkpoint?
I am aware that they're out there, sir.
You're aware that they're out there. Let me get this straight. You're testifying right now that you are aware that there are written guidelines and procedures for this checkpoint?
At the border, the cop wrongfully detained a U.S. citizen. When questioned by an attorney, the border agent struggled to defend the unlawful arrest.
Can you state that question again, sir?
Is it your testimony here and now that there are written guidelines and procedures for this checkpoint?
To my knowledge, yes, sir.
Have you seen them?
No, I have not, sir.
But to your knowledge, they exist.
Yes, sir.
Do you recall on June 1st of this year giving a telephonic statement to Mr. Victor?
I do not recall the exact date, but yes, I do recall a telephonic interview, sir.
Do you recall you were in a room with Mr. Katz?
Yes, sir.
I believe there was another attorney in the room who was a representative of the Border Patrol Union?
Yes, sir.
And you were on the telephone to Mr. Victor?
Yes, sir.
And you're aware that that tape recording was being recorded?
Yes, sir.
And were you trying to tell the truth at that time?
Yes, sir.
Do you remember being asked during that statement if you were aware of any written guidelines, policies, and procedures for this checkpoint?
The officer's lies were about to be exposed. A shocking call recording contradicting this previous claim was set to be played in court.
Do I remember that specific question, sir?
Yes, sir.
No, sir.
Do you remember saying that you were not aware of any written guidelines, policies, or procedures?
No, sir.
Would it help to refresh your memory if you heard a tape playing of your voice?
Yes, sir.
Your Honor, if I may? Tell me if this is your voice and if you remember being asked this question and given this answer.
And Your Honor, the state's going to object at this point. Was this noticed as part of your trial exhibit and disclosure?
Actually, Judge, this doesn't need to be noticed because it's impeachment, which is exactly how we're using it right now.
Your Honor, the same standard would apply to both parties. The state would expect everything that be given in notice to both parties.
Judge, the law's well settled in Arizona. If the defense had to give impeachment to the state of the state's witnesses before the state's witnesses testified, it wouldn't be much of impeachment, would it?
Just as the truth was about to be revealed, a shocking twist unfolded. Desperate to defend the cop's attorney objected to the evidence.
We're simply disclosing the audio tape of the interview that the state's witness, where the state's counsel was present throughout the entire interview.
Your Honor,
I have no understanding what possibly could be the objection to this.
Your Honor, may I have a moment?
You may.
Your Honor, Mr. Victor is quite correct. Under Rule 613B, the state withdraws its objection.
You may proceed.
Let's ask this question. Do you have any written policies, procedures, or guidelines on how the operation of that particular checkpoint is to be conducted?
No, to my knowledge, no. Is there citizenship there? If somebody's traveling through there, say, some sort of checkpoint, they're U.S. citizens, they're free to go. If they're not U.S. citizens, they say they are not.
Agent Gomez, did you recognize that as your voice?
Yes, sir.
Were you asked the question if there were any policies, procedures, or written policies, procedures, or guidelines for that checkpoint?
Yes, sir.
Was your answer that you were not aware of any?
Yes, sir.
Thank you.
state attorney's objection was swiftly withdrawn, allowing the defense to proceed with the audio playback.
To have your testimony correct that when people pull up and you ask them if you're a U.S. citizen and whether they answer yes or no, then they're on their way?
Yes, sir.
So if someone pulls up and you say, are you a U.S. citizen, and they say no, they're on their way?
No, sir.
Well, which is it? You just said if they say yes or no, they're on their way. But then I asked the question a different way. If they said no and you said they're not on their way, which one is it?
Usually if somebody says no, they already have their immigration documents with them. They present that to me and they're on their way.
And do I have your testimony correct that if you are unable to determine citizenship at the checkpoint, do you usually try to get them to go to secondary?
Yes, sir.
Not all the time?
No, sir.
So sometimes you cannot determine citizenship at the primary, but you just let them go.
No, sir.
And now I'm confused again.
The attorney's skillful questioning quickly exposed the officer's lies. The unprepared agent was no match for the legal expert.
You are unable to determine citizenship at the primary checkpoint, that you usually try to get them to secondary.
Yes, sir.
I did not say always try to get them to secondary. Do you understand my question?
Yes, sir.
Usually means sometimes not, doesn't it?
Yes, sir.
So is it fair to say that sometimes, if you are unable to determine citizenship at the primary checkpoint, that you let them go anyway?
No, sir.
I don't understand again. If someone comes up and you cannot determine citizenship, you say you usually try to get them to secondary. Is that correct?
Yes, sir.
Usually means not always. Is that correct?
Yes, sir.
Like, I usually wear a suit to court, but not always. Do you understand that?
Yes, sir.
Now the attorney turned his attention to the real victim, exposing the officer's true colors in a devastating display of legal skill.
So there are some times that people come up and you are unable to determine citizenship, but you just let them go on their way. Is that correct?
No, sir.
And what do you do with them?
I try to establish the citizenship there,
And suppose you can't.
and they go to secondary, sir.
So if you are unable to determine citizenship, they always go to secondary.
Yes, sir.
Not usually, but always now.
Yes, sir.
Mr. Anderson was sent to secondary inspection because of the dog alert. Is that correct?
It was a combination of both immigration and the canine alert, sir.
Okay. So you're saying part of the reason he was sent to secondary was immigration, not the
Yes.
dog alert?
Yes, sir.
But wasn't the decision made to send him to secondary, wasn't that decision made before he ever got to you?
Yes, sir.
And the decision was made, or you got the signal from Agent Spoonamore,
Correct.
before any immigration question was asked.
Correct.
And Agent Spoonamore gave you that signal because his dog alerted.
Correct.
The cop's downfall was imminent. He had been discredited twice previously and was now facing the final reckoning.
So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
The canine does not determine citizenship, sir.
So he wasn't sent to secondary for immigration. He was sent to secondary because the dog alerted.
Mr. Anderson never answered my immigration question.
But the decision that he was going to secondary had already been made, correct?
Correct.
He could have pulled up to that primary checkpoint with a passport in his hand, and he was still going to secondary. Is that correct?
Correct.
The lawyer wasn't finished yet. He exposed and defeated the cop with a forceful statement that silenced him.
Is there any better documentation of U.S. citizenship than a U.S. passport?
No, sir.
So it didn't matter what he said, he was going to secondary
Yes, sir.
because the dog said so.
Because the canine alerted to the vehicle, sir.
Is a canine trained to alert to people here illegally?
No, sir.
So the dog wasn't alerting for immigration.
The cop was brought down by the lawyer's unwavering dedication to justice and the truth. The illegal stop was exposed and the officer was forced to face the consequences of his actions. This officer's arrogance cost him everything. But wait until you see what this next cop did. It is almost unbelievable.
Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law.
In a shocking turn of events, Indiana State Police uncovered a massive embezzlement scheme involving Clark County Sheriff Jamie Knoll. The sheriff was charged for stealing more than $5 million from taxpayer funds.
Date of birth?
12/18/70.
Make you know.
52, sir.
And the last four digits of your social security number? What's your address?
3001 Old Tate Road, Jeffersonville, Indiana.
You have a good contact telephone number?
Yes, I do.
And the drugs including alcohol, please?
No, Your Honor.
Do you understand English language?
Yes, Your Honor.
Let's say something you don't understand. Can you let me know?
Yes, Your Honor.
Mr. Knoll, Special Prosecutor Pearl has charged you with 15 counts of criminal conduct. I'll go through them. Count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or about a period of time from November the 9th, 2018, and August the 16th, 2023.
The action was taken quickly when Knoll's offenses were exposed. With a startling 25 criminal charges, he was immediately removed.
Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain, either directly or indirectly, an interest in or control of property or enterprise contrary to the form of the statute in such case made and provided. Count 2, theft as a level 5 felony. It would indicate that pursuant to Indiana Code 35-44.1, you then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A, would indicate that between April the 30th, 2021 and September the 14th, 2022 in Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association.
The investigation took a dramatic turn as authorities discovered evidence connecting Knoll's wife, Misty, and daughter, Casey, to the embezzlement plan.
On or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation. That being, you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff, public servant, did knowingly or intentionally assign to Rodney Wobbly, an employee under your supervision, duties that were not related to the operation of the governmental agency that you served, that being sheriff, assigned Wobbly duties on your personal property, rental properties, father-in-law's property, pole barn, property of Utica Fire Department.
It was a shocking revelation that made people wonder how the sheriff, who was obviously breaking the law, managed to maintain his position for so long.
And count 15. Official misconduct is a level 6 felony. It would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being Sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being ghost employment as Sheriff of Clark County relating to Brent Fisher. Mr. Knoll, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail if treated as a misdemeanor to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
Yes, Your Honor.
Do you understand the potential penalties?
Yes, Your Honor.
As the judge read out the 15 devastating counts against him, Jamie sat calmly. The courtroom was tense as the state attorney argued for his detention without fail.
The next question is usually you intend to hire a lawyer, but you obviously have counsel seated with you. I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, severe question and cross-examine those witnesses. You have the right to have witnesses brought into court to testify on your behalf. And at your request, the court will issue subpoenas requiring those individuals to come into court to testify on your behalf or bring evidence in. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to remain silent. You cannot be required to give any testimony or make any statements against yourself to anyone.
The court defied expectations by granting Jamie bail, a move that would later turn out to be a serious mistake.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Being from the country, or as Mr. Wilder said, Washington County, I keep my shotgun with double-aught near me, along with a 45, but I think one shotgun for personal protection is appropriate for him to maintain. Will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Knoll, Mr. Wilder, I know you wanted to be released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you so please.
The judge, in a firm and decisive tone, made the decision quite clear, leaving no room for doubt or misinterpretation.
You keep one shotgun only. Try to deceive me, you will not like the consequences. Understand?
Yes, Your Honor.
And then, Judge, the issue of return of all other items, see if we can just take them in another hearing.
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
yes, sir.
we'll address in due time.
Thank you, Judge.
Anything else?
No, Your Honor.
Nothing else from us, Judge. Thank you.
All right, let's be off record. Thank you all.
After police discovered concealed firearms, Jamie broke his bail terms and was taken into custody again. This time, the judge delivered a severe warning.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
As the judge delivered his sentence, he took a moment to highlight the shocking fall from grace of the former sheriff.
You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Yes, Your Honor.
Oh, Mr. Boyles, I apologize, Mr. Boyles, your lead. Before he is released, I I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find it, Mr. Ertle's original argument that he was trying to make that I sustained, an officer of the law. Every time I go into court, I hear, I didn't know it was there. I didn't know it was there. I really did. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It's your burden. It's your responsibility. And today, the court will enforce that. Take it away.
The 60-day sentence is only the first step. It is unclear how severe his sentence will be because 31 felony charges are still pending. Well, that brings us to the end of this video. Today we witnessed some of the most shocking reactions from corrupt cops facing the ultimate punishment in court. These moments remind us that no one is above the law and that justice must be served to maintain order and accountability. Corruption and abuse of power come with consequences as evidenced by these cases. If you agree with me, please show your support by liking this video and subscribing. Stay updated on more compelling stories like this. Also, if you enjoyed this video, watch this devastating case when an officer discovered a dead body in a garage.
Yeah, there's a body.
Where?
You can see the legs from the far corner.